what I do. I represent, this is
You are
what
now
I
listening to the most electrified and vilified podcast on the net. Hot Topix Podcast. Let's get this party started. Welcome to the Hot Topix Podcast. This is your host, Psycho 4081, and I'm here solo today. Lamb Chop is on assignment, and Felonious Feather also is a little bit under the weather. So we have a special guest today. We have our prominent Maryland. Can I say Maryland?
Say Maryland.
Maryland attorney, Mrs. Tiffani Collins. How are you doing?
Hi, how are you this evening?
Good, good. So for those who don't know, I reached out to Ms. Collins to give us some information on estate planning. And one of the ideas that came about was because, you know, I'm always on social media and I browse things and I see all these different people who have, what do you call those things? GoFundMe for funerals, for this, for that. And I'm like, well, there's a lot of people here who do not actually plan on anything. And I'm one of them. I didn't plan properly and I'm going to fix that ASAP. But I thought estate planning was something that we all needed to know, all us responsible adults, and hopefully the listeners will come away with some information that'll help them on this complicated journey. And I say complicated because it's complicated to us. All right, we have somebody coming in here. All right, so first of all, we always like to qualify our guests, and I wanted to know if you could give us a brief bio, let the people know who you are and your journey to where we are today.
Sure. My name is Tiffani Collins. I am the principal attorney and owner of the Collins Legal Group, which is a boutique litigation firm located in Baltimore County. We're located in the Towson area. We specialize in all things litigation. The majority of our practice is based around injury plaintiff side work. So that is medical malpractice, traumatic brain injuries, birth injuries, police brutality and excessive force, car wrecks, slip and falls, workers' compensation. That kind of goes hand in hand with what we're talking about tonight. The other side of our practice deals a lot with estate planning, where we kind of help people make plans for how they would like to have their personal assets managed in the event of their incapacitation or, you know, ultimately their death.
Okay. So just for people who don't know, and I didn't know this until like fairly recently, what exactly is estate planning?
Sure. So estate planning is really the practice of determining how you want your assets to be managed and or dispersed in the event that you are incapacitated for health or psychological reasons, or if you die. So it is the exercise of essentially going through and looking at all the things that you own in your name and determining where you want those things to land in the event that you die, or how you want those things to be managed if you are unable to take care of yourself or make decisions on your own.
So in your professional opinion, I know, or personal life, how many people do you think actually prepare for these things?
Not enough.
Not enough.
Not enough. I think that with COVID, there was this big push for estate planning, and you ended up seeing a lot more people kind of gravitating towards asking the questions and scheduling the appointments. And then there's also been kind of this really big push on social media regarding estate planning. Now, not all the information is accurate. And so sometimes when we do consultations, we do sit down and we talk to potential clients and we explain to them that, you know, some of the things that they may have saw on social media or on the internet may not necessarily apply to them in their situation. I think it's getting better. I think people are recognizing the benefit of planning ahead, preserving their wealth. They're learning how to pass that wealth down from generation to generation. They're learning, you know, the generation skipping process. So I think that people are definitely getting more informed. So we're getting better, but still, you know, there's a large segment of the population who feels like, oh, I'm not going to die anytime soon. Nothing's going to happen to me. Or they feel like, if something does happen to me, I'll be old and I won't have any assets at that point in time. Somebody else will figure it out. There are people who believe that it's cost prohibitive for them to inquire and start making plans. So there's still I think a very large segment of the population who they're not there yet. They haven't taken that leap
Now,
to make those plans.
Would you recommend any specific age for somebody to go get into estate planning?
I think that if you're old enough to have an asset, whether that's a bank account or a property or a car, then you're old enough to have an estate plan.
Okay.
You are old enough to make a decision as to what's going to happen to that piece of property or that asset in the event that you're unable to take care of it or you pass.
Okay. And I'm going to go on a limb on this one. So I would say that you would not recommend getting your legal advice from TikTok.
I would highly encourage people to. TikTok is a great idea, but definitely follow that up with some true legal professional who's licensed in the state that you have assets in. A lot of people forget that part, right? Which is that different states have different laws. And, just because the person in California is saying, hey, I'm a lawyer in California, this is what I need to do. If you live in Maryland, then that's not going to apply to you. So you want to make sure that the information that you're getting and you're acting on is applicable to the state in which you're domiciled.
Okay, and you specifically, you're licensed in Maryland and DC.
Yes.
Okay. So for everybody out there, this specifically applies to Maryland and DC. Now, one of the questions I would have is, if I'm going to go into estate planning, what documents do I need?
So estate planning has two areas, right? You have the before death documents and then you have the post death documents. So before death, you're looking at things like your power of attorney. You're looking at your medical directive. Some people call it a living will. Some people call it a healthcare directive or a physician's directive. Those two documents are documents that you use to give somebody the authority to make decisions on your behalf or as if they were you. Right? So a power of attorney is a document where you're giving somebody attorney-in-fact power to act as if they were you. So essentially, you're giving this person the authority to physically put on your skin, and go out in the world and enter into obligations as if they are you. And so those documents, the power of attorney and the healthcare directive, those documents become null and void at the time of death. So they're only valid while you are alive.
Okay.
A lot of people think, okay, I'll get a power of attorney and, I'll take care of that. But the healthcare directive is equally important because if you have particular wishes about how you want to be managed in the event that you have some type of catastrophic injury, those are things that you want to have documented. And sometimes it's better for your loved ones anyway to have those decisions pre-made so that they're not struggling with decisions as to whether or not you should get artificial feeding, whether or not you should be on life support, whether or not you should get blood transfusions. If you have that laid out in the plan that these are your desires, it makes it easier for people to be able to act on your wishes.
Okay.
The power of attorney people use, and a lot of times people will use those without there even being an incapacitation. If you are, for example, away and you need to have something taken care of, you can give somebody a limited power of attorney to go and to act on your behalf. But here's an important point, and I saw this in court this week. A power of attorney does not give you the ability to go and represent somebody in court, right? It is not a document that grants you a law license, even though it says power of attorney. Instead, it's a document that just allows you to enter into contracts. It gives you fiduciary authority. You can sell and acquire real estate. Some power of attorneys will let you do things like get life insurance, change beneficiaries on life insurance policy. So there is a huge responsibility that comes with being somebody's power of attorney, but then you, the person who's assigning that right, you want to make sure you choose wisely also.
Now, if you have a power of attorney, can you change a person's will?
If the power of attorney grants you that authority in the document, then yes, you could make changes to a will.
Oh, okay. So
make changes to a will, you can make changes to a trust, but the power of attorney has to specifically grant you the power to do so.
Okay. Okay. And one of the things that we've actually had experience with was the executor. What exactly, first of all, what exactly is an executor?
Okay, so Maryland does not use the term executor. In
Okay.
Maryland, you are the personal representative, right?
Okay.
And so if you think of an estate almost like an entity, almost like a company, the personal representative is the CEO. The personal representative is the person who is appointed by the court to administer that estate and to make sure that all of the assets are accounted for, to make sure that if there are creditors, those creditors are paid. And then at the end of that, to make sure that any remaining assets are distributed either pursuant to the law or pursuant to a will if there's a will.
Okay. So if you were to select an executor, or you said personal representative,
Personal representative.
personal representative, what qualifications would they need? Or what
That
would
is
you look into?
great. That's a great question. And this is what I tell my clients all the time, right? A lot of times we'll have older people come in and their kids are adults now and like 20 something, 30 something, and they want to have a power of attorney. I'm sorry, they want to get a will. And the question becomes, who do you want to be the personal representative? And they'll say, well, can they both serve or can all three of them serve? My answer to that question is always no. There's a saying about too many cooks in the kitchen.
Yes.
That applies in this situation, right? You don't want to ever have a situation where multiple people need to work together to arrive at a consensus to make a decision. It becomes taxing and extremely difficult, and it can create a toxic environment where there wasn't one before. So what I tell people is this: who is the child who pays their bills on time? Who is the child who is responsible? Who is the child who is responsive? Who is the child that checks their emails regularly? Who is the child that responds to text messages regularly? That is the person you want to be your personal representative. You want it to be somebody who can manage money well, although the court kind of requires certain financial reporting throughout the process of administering an estate, but you want to make sure that you choose someone who can manage money well. You choose someone who can follow directions well. You want to choose someone who understands that, listen, this is something that's very important and I have to follow the letter of the law in order to do it. That's who you want to be your personal representative, not your favorite child. It may not be your favorite child, right? And so you want somebody who's not going to cave, because if there's a will, you want them to follow the will to the letter. You want them to be responsive to the court so that they're filing these inventories and these accountings. In Maryland, you have to file them semi-annually, so every 6 months. So you want to make sure that it's somebody who is good with deadlines and kind of good with staying on top of things. And here, at the end of the day, you can always hire, the personal representative can always hire an attorney to manage that process.
Okay.
And so a lot of clients come to us in a probate state also, and they say, hey, I'm personal representative of this estate. I have no idea what I'm doing. Can I just hire your firm to do everything? So you want somebody who knows when they're in over their head, if it's too complicated, and that they're going to follow through and kind of do everything that they need to do.
Okay. Yeah, it does sound pretty complicated. One of the things I was thinking about in regards to that is, would you factor in a person who might be, maybe too emotional to handle those type of things?
So being a personal representative, if we're just talking about administering an estate, is not an overly emotional job, right?
Okay.
However, people who have people who are overly sentimental, it may be difficult for them because they may not want to part with grandma's house, but you got to part with grandma's house because we got to liquidate liquidate the asset. They may not want to give anybody any of the personal property stuff, the pictures or the clothes or the jewelry, because it's sentimental to them and they want to keep it. So you certainly don't want you don't want a selfish person. You don't want someone who is overly authoritative, meaning that they're going to try to control the disbursements.
Okay.
Especially if you think that they may not properly disperse the assets in accordance to your wishes, right? So the emotional part of it, it's not taxing. But if you have someone who's super sentimental, who does, like the person who hoards everything, who doesn't like to give anything away, you don't want them to be your personal representative.
Okay, that's good to know. Now, you mentioned a will and a trust.
Yes.
How does a trust differ from a will, and what's the benefits from setting up one? 'Cause
Okay.
I heard there was two different types of trusts.
There are two different types of trust.
Okay.
We're going to do it in reverse, right? So what does a will do? The will is the controlling document when a person dies. That the will determines who the person wants to appoint as their personal representative. It also outlines what they want to happen with their personal property. Now, in order for the will to be controlling, whatever that property is, whatever that asset is, it has to be titled in the name of the decedent. So if I have a house and my house is titled in the name of Tiffani Collins, then that is something that I can disperse or bequeath or give away through my will. Okay. So the will is only for things that are titled in my name at the time of my death. If you pass away and you have bank accounts in your name, your will is going to control what happens with that. So your will is basically just your written testimony. That's why they call it a last will and testament. Okay. So it's your written testimony about what you want to happen to the things that belong to you and that are titled to you upon your death. So it'll identify who you want to administer your estate, who you select to be the personal representative. You can make requests for who you'd like to be the guardian of your children, if you pass away. You can specifically decide to disinherit somebody. You can say, listen, Brenda was a great sister to everybody else, but she was horrible to me and I don't want her to have anything. And you can specifically disinherit her. So you can protect your assets from people, and then you can also give your assets away from people.
Now, does that include marriage? Let's say if I died and I had a wife and I wanted to give all my assets to a cousin.
Mm-hmm.
Does that mean that's what'll happen, or does the wife still have a say in that, being that she's the wife?
So there's a way to draft a will to allow for you to specifically disinherit a wife. However, Maryland law affords a spouse a certain share of an estate, no matter what, right? There are things that you can raise, right, that you can raise to say, hey, that shouldn't apply. Like if you and your wife are estranged, if you've been separated for years, things like that. But in a will, if you are specifically disinheriting your wife, you have to put that language in there. And then that language has to withstand any challenge that she may raise for her statutory share.
Okay. So in that case, it's best to get an attorney for that type of stuff, because the average person wouldn't know the language to put in.
If you're trying to cut your spouse out, please go get a lawyer. You might want to see a divorce lawyer if it's come to that, but at least see a proper estate planning attorney. So that's what a will does. A trust is a whole different animal, and there are two different types of trust. There is a revocable trust and there's an irrevocable trust. Typically, when people are talking about starting or creating a trust, it's because they want to protect one or two things. They want to protect themselves from liability, or they want to protect themselves from taxation, right? With a revocable trust, you are able to protect your assets from liability. So what does that mean? That means that if you take your assets and because you have to retitle them, a lot of people don't understand that. You can't just say, I have a trust, and so now all of my stuff is in the trust. You have to show that you are retitling the ownership of that stuff. So for example, if you had a car, you would have to sign the title over into the name of the trust. If you had a house, you would have to change the deed and put the deed in the name of the trust. If you had personal property like fur coats or jewelry, you would have to do a Schedule A identifying each item that you were now turning over to the trust. There has to be something to show that there's been a transition of ownership in order for you to claim that you don't own it anymore. Okay? So with a revocable trust, you have the ability to go in and to change it. Some people refer to a revocable trust as a living trust also, because it gives you the ability to make changes.
Okay.
The person who is creating the trust or funding the trust is usually referred to as the grantor. So the trust can exist while the grantor is alive, and then the trust can have specific provisions for what to do with the assets of the trust once the grantor passes away. Okay.
Okay.
Then you have an irrevocable trust. An irrevocable trust is a trust that once it's created, you can't make changes to it. The irrevocable trust is what's going to give you liability protection, but it also gives you taxation protection for assets that generate income. So when you think about assets generating income, you're thinking about we're looking at investment accounts, we're looking at rental properties, we're looking at business interests, anything that generates an income and you want it to come in through the trust. Now, here's something, and I'm not going to go too deeply into it because accounting is not my area. I'm all about the law. But what I do explain to people is that, you have to understand that while there is some protection for the monetary assets in an irrevocable trust, there is taxation on draws or disbursements from that trust. So while you may protect the actual income as it's coming into the trust itself, but when you make any type of payments, when you take any type of disbursement from that trust, that could be a taxable income for you as an individual. So there are some protections for the asset itself, but not necessarily for the beneficiaries.
Okay. I think that's a lot of people are looking into trust just because they think it's going to be tax-free money and no penalties.
That's what they think, because that's what TikTok told them.
That was me.
There's a whole different element. There's a whole different element to it that you have to explore, and you need to talk to a tax professional about that, how you manage those disbursements, because creating a trust doesn't just give you a separate piggy bank that's not in your name. And I think that's what a lot of people think when, they come to me and they say, hey, I want to start a trust. And I'm like, okay, great. Tell me what assets you have. And they say, oh, I don't have any yet. Well, you got to fund a trust, and so, even if it's $10, you have to fund a trust in order for it to be created and formed correctly.
Okay. Going back to the documents that's needed, if somebody wanted to, do a will, they would make an appointment with an attorney. And what are some of the documents that they would actually need, or would they find that out from the attorney at the time?
So it depends on what you want to do, right? Like when we are doing wills, we have people bring us a lot of things you can find online. Like, 20, 30 years ago, they would tell you to bring a copy of your deed. I don't need you to bring your deed anymore because if you live in Maryland, I can pull your deed up. If you live in Washington, D.C., I can pull your deed up electronically. Ooh. But if you do have anything like CDs, mutual funds, life insurance policies, any documentation about any other type of asset that you want to have dispersed at the time of your death, you want to bring all of those things with you so that you can make sure that everything that you want to give away is properly identified in the will.
Okay. That's good to know. So now that's a lot. That's a handful. Now, what actually happens if, let's say, somebody passes away and they don't have a plan? They don't have a plan. They don't have a will. They have nothing. What actually happens?
Well, in Maryland, the statute controls. So you still go through the same probate process, but disbursement is based on Maryland's statutory list of privity, meaning that disbursement is based on what the statute says who should receive first, right? So if you are married, the statute says it all goes to the spouse. Okay. If you're not married and you have children, then the statute says, okay, it goes to the children, right? And it's going to go to the children per stirpe.
If you put on the...
Sorry.
Which means that it's going to go to the children per stirpes, and per stirpes means in equal shares. So if you pass away and you're not married, you have two children, the law says that your assets are going to go to your children and they're each going to have 50%. If you have 4 children, they're each going to have 25%. It'll be per stirpes in equal shares. If you don't have children, then it's going to go to your parents. If your parents aren't alive, then it's going to go to your siblings. So it kind of follows that order based on what the statute says.
Okay, that's easy enough. Now, let's say a young man like myself, if I wanted to do have my estate plan already done up and whatever, how often should I review it, or just let it ride?
So it depends, right? You are not required to make changes to your will unless, one, you acquire something that you want and you want specifically for that thing to be given to someone, then you need to make a change to your will. You need to add that information into the will. There's this thing called a pour over will, which is basically like when you set up a trust, whether it's revocable or irrevocable, you set up a trust and you want to put all your assets into the trust while you're alive. You can create a pour over will that will say that in the event of your death, any assets that you have, you want them to also be turned over to the trust as well, right?
Okay.
You can have both. You can have a will and a trust where you have the things that you want in the trust are in the trust, and then in the will you have specific distributions, or you're bequeathing specific items to specific people. So you can have, they're not mutually exclusive. You can have both at the same time.
Okay. So obviously we brought an attorney here to talk about all the things that we need to know. And obviously is a lot of things that most people won't know. What other professionals should a person consult when doing estate planning? Obviously is an attorney, and who else?
An accountant and a financial planner, especially if you have cash assets. And if your intention is to create a situation for generational wealth, where let's say, and you see this a lot of times with wealthy families, which is that the grandparents their money will skip their children's generation and then go down to their grandchildren, right? So we call it generation skipping. So you want to make sure that you have the appropriate tax provisions. If you have an estate that's in excess of, $1 million or $10 million, you want to make sure that you have the proper financial advice about what your tax implications are going to look like. If you are setting up a trust to reinvest its money, so you want to pay out dividends. So let's say you fund the trust with $1 million, and then that $1 million is turned over to some type of retirement or equity firm that's kind of investing it, and then they're producing a return every quarter, and so the trust is set up so that it's paying out the profit. Then you also want to make sure that you're consulting an accountant and some type of financial planner to make sure that the investments are solid, that you're getting the proper rate of return on the money that's being invested, and then what the tax liability is going to be for the beneficiaries.
Okay. So with the will, I'm going to assume that is going to be my guarantee that my wishes will be followed. Or is that, flexible?
No. So it's not going to be flexible. I mean, as long as it is in accordance with the law, if there are illegal provisions or unlawful provisions, then obviously they're not going to be enforceable. But I mean, with a will, it's pretty hard to draft a provision that's not going to be enforceable. So if you say, I don't want my son to get anything, and you put the language in there to properly disinherit him and his heirs, then he and his heirs are going to be disinherited.
Okay.
A common provision that people put in there is about contesting, right? Like if you contest the validity of a will, you will forfeit your right to collect under that will.
Okay. So in other things I was looking at was the funeral arrangements, or how I want to be disposed of. I hate that's a nasty word, but how are you going to be disposed of? Is that actually put in a will, or is that something that's that goes on something else?
So typically what you're going to find in the will is how that is to be paid for, meaning that the will make provisions for payment of funeral expenses or burial expenses off the top. So let's say that, when you read the will, there's $1 million in assets, and the will may say, before any asset is dispersed, all of my funeral arrangements need to be paid for. paying for the funeral arrangements reduces it from $1 million to $950,000, right? So it's
Right.
not $1 million now that's being dispersed, it's the $950,000 that's being dispersed. In your healthcare directives, you can also specify how you want your remains to be disposed of, whether you want to be cremated or buried or donated to science, if you want to have your organs donated to science and something else done with your body. So you can specify it there as well.
Okay, and that's concrete.
So
Uh-oh.
this position is not always concrete. I mean, because, once you're deceased, right, technically your personal representative, if one has been appointed at that point in time, which usually that's not the case. And so you got to think about how it works, right? So in order for you to have a personal representative, that personal representative has to be appointed by the Orphans Court in Maryland. What that means is that in your will, you're nominating this person to be your personal representative, but the court gets the final say. The court has to issue what we call an order. We refer to them as letters of administration that appoints that person to, in fact, be the personal representative. Typically, an estate is not going to be opened until after the disposition ceremonies have taken place because you need a death certificate to open an estate. So you're in this limbo phase where your healthcare directive isn't completely controlling because technically you're deceased and those documents become null and void at that time. But then you also can't enforce a will because you don't have a personal representative because the death certificate is probably not ready yet.
Oh, question on that one. Speaking of opening an estate, let's say you don't have a will and you have a child, a minor child, is your I guess your heir, and you have a father or sister or aunt or whatever. Who takes priority over that?
Who takes priority over caring for the child?
Not caring for the child, but like the disposition of your assets or your property.
So it depends, right? I mean, essentially, there's not going to be any document that gives anybody authority. The personal representative is usually expected to be the person who's going to handle that, or whoever is the next of kin, right? So if it's a husband and the expectation is that it's going to be the spouse. If there is no spouse and the expectation is that it's going to be the child, right? If it's being paid through an insurance policy, typically the funeral home is going to listen to the person who's the beneficiary of the insurance policy.
Okay.
So, it really just depends. And that's why you find yourself sometimes in circumstances where people are fighting about who gets to make the decisions.
So a minor child doesn't have.
They can't enter into any contracts.
Okay, so it's the next adult. Gotcha. Okay. Okay. Did you mention the living will?
That's what people also refer to the healthcare directive.
Okay.
So you have call it medical directive, healthcare directive, living will, physician's directive, but it's based, or you may even hear it referred to as a healthcare power of attorney. But it is a document that grants the person of your choosing the right to act as your healthcare agent and make healthcare related decisions on your behalf if you are incapacitated and unable to do so.
Okay. Well, I don't have any more questions. I think you answered pretty much everything. We do have some people who joined us, and I'm going to ask them, do you have anybody out there who's listening now? Do you have any questions for our resident attorney? If not, can you give us the, we have a hand. That is, okay, I'm going to unmute.
Good evening. Ms. Collins, could you please put, I guess, in the chat your contact information?
Sure.
Yeah.
So we're going to have, I'm sorry, we're going to have her contact information, numbers, the whole nine, in our website at www.hottopixpodcast.com. And it's going to have everything in there. So you guys can just go under the forum, because all the different notes that we have will be in that forum if you want to, check it out.
All right. Yeah.
Good. Okay. And something smells good in here. Anybody else? Now, again, if you do have any questions, you'll be able to get her telephone number, website, and it's a very informative website because she's actually was my attorney as well. So, and she does a great job, I might say.
Thank you. I appreciate that.
And for our subscribers, we have our word of the day is going to be will. So for anybody who doesn't know, every podcast we give out a word of the day. And at the end of the month, if they have all the words of the day, then they'll get a free well, I'll say free. It's not free to me, but they'll win a prize. So it's the first come, first serve. Whoever, emails us all the words of the day, you'll get a prize. And most likely this month, it'll be from our sponsors. We have the Purple Flip, which is a juice and smoothie company, really good stuff, and Pizza City. So want to make sure we put that out there. And just want everybody to know we have part 2 of our last episode. We're going to talk about Diddy. That's for people who get into the law and order and the crimes and this and that. So we're going to have that coming up on Monday, and our co-host will actually be back in time. Let's see. If you do have any last questions, just raise your hand if you know how, or put it in the chat box. You can get those out there. Otherwise.
Hello.
Oh, we have one. Okay. How are you?
Yeah. Okay. Sorry, I'm on the phone. I have a question. If you have a will, is it proper to disperse that to the people who are going to benefit from the will, that they have a copy, or you keep it under lock and key until you pass away?
So we produce multiple original copies in our office. We produce 5 original copies. You should have a copy for yourself. You should have a copy for the person that you are nominating to be your personal representative. In Maryland, you can file a copy with the Register of Wills at the Orphans Court in whatever county you live in. And then in our office, we keep one on file also. But they have to be originals, meaning that they have to have wet signatures. You cannot probate a photocopied will.
Okay. All right. Thank you very much.
That was a pretty good question, actually. So,
sometimes it's better to keep it under lock and key anyway, because folks, they're never happy. We have a saying in our office that nobody fights harder than people fighting over money that they didn't earn.
So I always thought that they would just contact the Register of Wills, and all wills had to be legal, I guess.
It's not required.
Oh, nope. Okay.
And a lot of people don't know that wills, you don't have to have, the will does not have to be notarized. Maryland law doesn't require it to be notarized. It requires it to be signed in the presence of 2 witnesses, and the witnesses need to also sign the will as well, but it does not have to be notarized. It's good to have a will filed with the Register of Wills, but sometimes people will file them, and then life will change in 10 or 20 years, and they'll do a new will, and there'll be new versions, and they'll forget to update the Register of Wills.
Wow. So just playing devil's advocate, would it be unreasonable to assume that somebody could, type up their own will and say somebody else did it if you don't have to have it notarized or, registered?
Well, you can write your own will. I mean, you can write it on a piece of paper. It just has to be signed, and then you have to sign it in the presence of 2 witnesses who sign under penalty of perjury that it was signed in their presence. Okay, so 2. Okay, so I couldn't just say, well, I'm a draw. I know Tiffany didn't do a will, so I'm gonna just type one up for her, and I'm gonna sign it, and just when that day happens, I'm gonna collect all your stuff. No, you have to have witnesses. 2 witnesses to verify the signature. Yeah. Okay. You have to identify those witnesses on the will. It has to be verifiable. Okay, thank you. So, if there's no more questions, and I'm looking on a thing just to make sure. Thank you for taking your time out of your busy schedule. I know I always get on you about being overworked. I'm still here. No. Well, and I kind of felt guilty about it, because I always told you, I said, you work too hard, you work too much,
You know, then I'm saying, hey, can you come do a podcast with me?
We're here to help the people. So, when duty calls.
So you guys, if you can take the time out, I know I'm not just talking to the people who are listening now, but you can follow us at www.hottopix, that's TOPIX, podcast.com. And we have a number of 443-860-2716. If you want to leave a message or a text, we, monitor that as well. And I want to thank you all for coming out, and hopefully you catch us on the next one.
Absolutely.
Thank you.
Thanks for having me.
Thank you. And we're gonna have to get you back out here again for something more spicy.
All right, let's talk about all things Diddy.
Okay. Here we go.
Thank you, family, for listening to the latest episode of Hot Topics. As usual, listen, like, share, subscribe. Ta.
This is what I do. I represent, this is what I do.